Okay. Ladies and gentlemen, if everything is correct, you can all hear me. I cannot see you, but I see some of our the people who will do an introduction. But I will open this online conference webinar discussion on the casebook on judicial review of administrative actions. My name is Rob Riddershoven, and I'm a professor of European Administrative Law at Utrecht University. I'm also one of the authors of the casebook, in particular responsible for the chapter on appellate proceedings. But I'm opening this webinar in again another capacity, namely as one of the founders of, and still member of as well, the editorial board of REALaw, the review of European administrative law, and the journal organizing this webinar. Therefore, I will say a few words on REALaw and its connection with the casebook. But before doing that, one caveat. This webinar is recorded, and the recording will be put online on the upcoming REALaw blog at the start of the new academic year. So if you do not want to become too world famous, you can still put out your camera. Okay, that was my caveat. But returning to REALaw. REALaw is a journal which was launched at an international conference at Utrecht University in 2007. So next year we celebrate our 15th anniversary. Founding of the review were, besides myself, of course, Jan Jans, Sascha Pregal, and Sascha Pregal is our current Dutch judge in the European Court of Justice, and Karsten de Graaf. Besides Jan, we are still involved in the journal as members of the editorial board. However, nowadays the real hard work is done by the general editors Marjolina Eliantonio and Sofia Rangordas, the managing director Annalisa Volpato, and our blog manager Isolde Mariek. REALaw publishes scientific articles, case notes, and book reviews in the field of European administrative law, the impact of EU law on national administrative law, comparative administrative law, and the interaction between the European Union and national institutions. Publishing decisions are based on double-blind peer review, so we are very much academia-proof as well. What distinguishes REALaw from other journals in the area of European law and makes our journal rather unique is that REALaw really focuses on the interaction between national law and European law. So on one hand, we do publish articles about top-down influence by EU law on national administrative law. But on the other, however, many articles have a typical bottom-up approach and concentrate on the influence by the national laws to member states on the development of EU law. After all, subjects such as general principles of union law or state liability for breaches of union law did not come from nowhere, but have been inspired by the legal systems of the member states. It is this combination of top-down and bottom-up influence that has contributed significantly to the development of a jus commune within Europe. In this development, REALaw has played a modest role, and in this respect, the ambitions of REALaw are very similar to the jus commune casebook for the common law of Europe, of which we will discuss today, the volume on judicial review of administrative action. In fact, such casebooks provide the necessary legal cases, materials, and texts on which article and case notes to be written in REALaw can be based. Therefore, I'm looking forward to the online discussion of today, and I sincerely thank in advance already Professor Giulio Napolitano, Michał Krajewski, and Professor Marjolina Eliantonio for their contributions to the discussion. And we from REALaw hope that after the discussion, you have become so enthusiastic about the ambitions of the casebook and of REALaw as well, that you will come in touch with us and will contribute articles to REALaw and of course to our REALaw blog, which will be starting in the beginning of next academic year. But for now, I have opened this discussion and I give the floor to our moderator of today, Michał Krajewski. Michał, you have the floor.
Mike. Sorry, can you hear?
Okay. Again.
You got muted automatically for some reason.
Yes, I'm unmuting myself now, and I think after a second I get muted. Okay, I think now it's fine. So thank you very much for this invitation. I was very excited to receive it, and I'm looking forward to listening to all the comments and to the debate about this book that I will allow myself to say I find very important. I think that this book fills a very important research gap in European and comparative administrative law. I found it very helpful while working on my own book in the last months of work that related to judicial review at the EU level rather than comparative judicial review. But I think that this is important about this book. It provides us with an overview of standards and solutions and arrangements relating to the judicial review of administrative action across jurisdictions. And not only it shows us how EU law can affect these solutions and arrangements, but also it provides us with knowledge to better understand why certain EU law standards are formulated. So law on the judicial review of administrative action in the EU, it's sort of a feedback loop, right? Different solutions affect European solutions, and then these solutions have an effect back at the EU level. So this is why I feel this is a very important book, filling in a very important gap in the literature. I think it will be useful to the academics, to practitioners, also to the EU judges formulating the standards for the judicial review of administrative action, undoubtedly. So I'm looking forward to the debate, and let me first introduce our speakers today and our debate. Our debate will be conducted in an interview format with some also questions encouraged from the audience. And here, first is the message to the audience. Feel free during the debate between Mariolina and Giulio, feel free to write your questions and comments in the chat. I will be monitoring the chat permanently, and I will try to transfer your questions and comments to the floor to facilitate the discussion. So please feel free to jump in with your questions and comments. And later, after approximately 45 minutes, I think, there will be also an open floor to the debate among the participants in our event. And let me just briefly introduce our speakers. Mariolina Eli Antonio is one of the editors of the book. She's professor of European and Comparative Administrative Law and Procedure at the Law Faculty of Maastricht University. She studied law at the University of Teramo and Maastricht, and then in Maastricht she finalized her PhD, which also related somehow to the topics we'll be discussing today. It's one of the first books on Europeanization of administrative justice. So it's really nice to see that Mariolina is still pursuing this interest and still is contributing to the field. Her research currently focuses on the enforcement of European law before national and European courts. She has published extensively on shared administration, composite procedures, environmental law, and new modes of governance. And Giulio Napolitano is who will be conducting the interview, who will offer first his comments and his questions, is professor of public law at the University of Roma Tre. He is a graduate from Roma La Sapienza, and also he earned his PhD at Scuola Superiore Sant'Anna di Pisa. He also worked at Roma La Sapienza and was an associate professor at La Tuscia University before moving to Roma Tre. And in the past, he also studied at Max Planck Institute in Heidelberg and at the New York University School of Law. He published extensively in the fields of theory.
Okay, Michael, it's enough. It's enough.
Okay.
Thank you so much.
Okay, then if it's enough, it's enough. And I will give the floor now to Giulio. Thanks so much.
Thank you so much for this very kind invitation. I'm very happy to be here. I really love the review that Mariolina and Maria so well prepare and publish regularly. But I'm very happy to be here to discuss with Mariolina this amazing book on judicial review of administrative action, because this book is something we never had at our disposal before. Of course, judicial review is traditionally one of the most developed area in comparative administrative law. We all know that legal comparison in administrative law is not an easy job, and it has not the historical underpinnings and the old tradition that legal comparison has in civil law or in constitutional law. However, despite this delay, comparative administrative law is growing, and we know this from very different initiatives that have been started in Europe and outside Europe. We all have in mind, I think, the two amazing editions of comparative administrative law edited by Susan Rose Ackerman and now the last one with also the contribution of Blake Emerson, which collect the two great conferences that were held in Yale. And of course, we also have an important development of European administrative law and comparative administrative law in Europe. And very recently, it was also published this new treaty of comparative administrative law edited by O'Kane and now published by Oxford University Press. But these are all very important contributions, but this is by far the richest book we have now. Of course, we can easily understand this from the dimensions of this book, but beyond the purely quantitative element of dimensions of number of pages, what I want to stress is the fact that this book is based on very different materials. All of them are very helpful, both for students and for scholars. These materials include classical readings, the text of statutory provisions, and above all, most importantly, cases and rulings by national and European courts. This book has another great virtue, I think, which is the fact of comparing national systems of judicial review, in particular with reference to France, Germany, United Kingdom, and the Netherlands. But it also includes the supranational level, the European Union judicial system, as well as the contribution provided by the European Court of Human Rights. So I think this is a big progress in legal comparison in administrative law. And said that, I want to raise two issues, two questions to Mariolina as it concerns these preliminary methodological issues. The first one is the extent of legal comparison. In particular, you focused your attention on the European Union legal systems, on the European Union jurisdictions. So the first question I wanted to raise to you is this a kind of needed limitation, as we assume that legal comparison is fruitful only within neighbor countries, or to some extent similar countries, or to countries that are subject to a common supranational legal order? Or do you think that legal comparison in administrative law, and in particular as it concerns judicial review, can be broadened and extended also outside Europe? And secondly, my question concerns the micro comparative approach versus the macro comparative approach. I mean that this book is extremely detailed, and all the main issues of judicial review are dealt with: constitutional foundations, the organization of the judicial systems, the different types of administrative action, access to courts, standards of review, structure and style of judgments, alternative dispute resolution system, liability claims. And the comparative analysis is extremely detailed and brings great added value, in my opinion. But authors refrain from making general assessments or broader comparative remarks. Do you think that only micro comparison is to some extent scientifically possible? Or do you think that micro comparison can be to some extent matched with macro comparison? Thank you so much.
Thank you. And now the floor goes back to Mariolina to answer this first round of questions.
Thank you very much. And first of all, I want to thank, of course, Rob for this wonderful introduction, and Michał for accepting to be here today and spending so many nice words about the book. And of course, above all, Giulio for accepting to be with us. And of course, a special thanks also goes to Iseult Maric, whom Rob has mentioned already at the beginning, who has been the mastermind behind this event today, and whom we should already be grateful to. Giulio raises two very interesting points, which I think really go to the core of, well, legal comparison, if you wish, beyond public law, beyond judicial review. These are also questions that we have discussed or pondered to some extent in the making of the book. Now, with respect to the first question, is the limitation to the to EU member states and the EU, is it needed? Is it only meaningful to do comparative law between neighboring countries, or can this comparison be broader? I think that in order to answer this question, I should spend a couple of words on the rationale of the casebook and the collection in which it is placed. I think Rob mentioned in the beginning that the casebook is part of this group of casebook founded by Professor Walter van Gerwen that is called Casebooks for the Common Law of Europe. So one of the underlying rationale back in the days when the first tort law book was written, which is when I was, I think, a student, the first edition of the tort law book came out. The idea was to do comparative law to also check to which extent national laws had been Europeanized, and therefore the extent to which national legal systems in that specific area were undergoing a process of convergence under the influence of European law. So seen from this perspective, if the, let's say, the lenses which we use to do comparative law is to some extent to also assess the degree of Europeanization, the degree of convergence, it does make sense to only limit yourself to the European legal system. Of course, nothing prevents, and in fact, that's a debate that is definitely worth having with you, but also with the member of the audience looking to the future of the casebook. One could imagine a broader casebook with more legal systems, with more families representative, the Nordics, Central Eastern European countries, because they may portray a very different image of Europeanization and convergence than we have now investigated in our casebook. However, of course, this is not the only reason why one might want to compare. And if one, say, puts aside for a moment the Europeanization/convergence lens, of course, there is meaning, and much more than only meaning, to do comparison beyond the EU and to not limit oneself to only neighboring countries. But there, I would say that the lens, the perspective, could be a useful one, could be that of, for example, legal transplants. So to see to which extent certain institutions present in one country have been adopted, have been taken over, possibly reshaped in a different legal system. And there I see no reason why in that sense, the certain geographical boundaries would need to be maintained. But there, I think the selection of the legal systems ought to be different because the rationale is a different one. Moving then to your second question, micro versus macro comparison. I think that's also a very important one. And I think to some, or not to some extent, I would say my direct answer is that both have value in themselves. And I do not think that one, let's say, can on its own can say everything a legal comparison can say, let's say. But I think that in our book, let's say, and in the way we structure the book and also the nature of the case book, the work lend itself more to this micro comparison, as you labeled it. And when it came to the possibility to write a general comparative chapter that would be, if you wish, an overarching conclusion on top of the conclusions that we had in the single chapters, me and Professor Bacchus, my co-editor, we hesitated because we felt that that would, to some extent, also distort a little bit the nature of what we had done up until that point, and that it's difficult to do macro comparisons if one doesn't take a very holistic then perspective, which would then for our purposes remain necessarily a bit too broad and too general. So we refrained from carrying out the macro comparison, but that would have been certainly an additional perspective and certainly a useful one.
Thank you very much, Mariolina. Now for the second round, I will give the floor back to Giulio, but I would like just to remind to those listening our conversation that if you have any questions or comments that you would like to share during the discussion, please feel free to type them into the chat box, and then I will bring them to the floor. So thank you, Giulio. The floor is yours.
Thank you so much. I think one of the most relevant changes in the legal regulation of judicial review has been represented in the last 50, 60 years by the growing relevance of constitutional constraints on the design and concrete functioning of judicial review. And this is a very interesting point in comparative administrative law, because we were traditionally used to look at the French model, at the French system, which was built up without any constitutional foundation. And even more surprisingly, still today, the most important system of administrative courts, if we can say so, the French one, remains without any specific or textual constitutional foundation. So the Constitution, the French Constitution in 1958 does not mention even the Council of State and its judicial function. And even after the reforms of the last decade, the constitutional reform of the last decade, this loophole was not covered. And so this is still a missing point in the French Constitution. But this doesn't mean that the Council of State and the other administrative courts haven't a constitutional dimension or a constitutional role. And even the Constitutional Council in French acknowledge that there is an area of reserved jurisdiction of the administrative courts on the basis of a certain interpretation of the French Constitution, of the French legal system. On the contrary, we have other relevant European Union member states in which there is a specific foundation of the system of judicial review in the Constitution. Perhaps the most detailed and clear is the Italian Constitution. Other constitutions are to some extent in the middle. The German basic law makes some references and stresses the subjective dimension of judicial review. Other constitutions, as the Constitution of Belgium, for instance, mention the role of the Council of State, but leave room to the legislator to define and circumscribe the area of administrative jurisdiction. So, in your opinion, does a constitutional foundation make a difference or not? Or to some extent, the history and the evolution of judicial review in Europe reveals to some extent an extra constitutional foundation or dimension of administrative law, and more specifically of judicial review?
Thank you, Mariolina.
Thank you very much. It is not an easy question, Giulio, and I think it would be interesting also to hear from the members of the audience who come also from different legal systems what their opinion is. In our work, at least what we have been able to, well, also live through, because this casebook, of course, took a number of months and years to conclude. Also in the discussions we have had with our authors, I personally did not have a sense that, for example, this lack of constitutional foundation, which you have just mentioned with respect to France, did make a substantial difference with respect to the eventually, if you wish, yeah, the foundation, the underpinning of judicial review with, for example, respect or in comparison to Germany. Of course, in our work, we have found countless times in which this Article 19 of the German Basic Law has been mentioned and evoked in several of the chapters of the casebook. But whether now we could sense that because of this, the lack of a similar article, the French legal system had a different kind of constitutional attitude to judicial review, it did not seem to me to be the case. Now, of course, the UK has been throughout this process always a little bit the odd one out in that sense. So there it did become clear that the lack of a precise reference to administrative courts or reference to a right to access to court, a right to judicial review in any of the, let's call it constitutional documents, it did perhaps make a difference in terms of cultural approach to judicial review, but that might also be linked to other factors which are not just the lack of constitutional underpinning, but more the historical evolution of the system of judicial review of administrative action in England, in the UK, more in general, in the first place.
Thank you very much. And now back to Giulio for round 3.
Another very important issue which is analyzed in the book is the organization of judicial review. And this is in particular one chapter written by Mariolina. And of course, this is really a key issue when we compare judicial review. Traditionally, we are used to oppose the systems in which there is separated administrative court, as in France, and the countries in which there is a system of ordinary courts only in place, as the United Kingdom and to some extent the European Union. And in the middle, perhaps we have Germany, in which administrative courts are special courts, but not separated from ordinary courts. So I wanted to ask you if this traditional difference, this traditional opposition, is still relevant today or not, or if on the contrary, the fact that many intermediate arrangements have been developed through time, including in the United Kingdom, the establishment of an administrative court within the High Court, or the growing similarities between administrative courts and ordinary courts in terms also of individual status of judges. All these changes have greatly vanished this old and traditional opposition.
Thank you, Giulio. Yes, that indeed goes to the core of chapter 2, and I sense also from the way you posed your question that you tend towards the answer that there is more nuance than just the two major subdivision that we have perhaps grown up with in that sense. Now that is to some extent also confirmed in our from our investigation. First of all, I would say that in this discussion there is more that meets the eye, in that sense that one needs to go beyond what seems to be the surface, let's say, to understand really how the administrative courts or courts doing judicial review are placed within the general court structure. And perhaps Rob can also intervene, as I want to give the example of the Dutch legal system, because of course in the beginning the idea we had was, well, ordinary courts or administrative courts are, you know, do courts that control the administrative action, are they ordinary, are they administrative? And in first instance, at first glance, one would say, well, in the Netherlands, these are ordinary courts, because there are no such things as administrative courts that are called like that. But then, because they operate according to a totally different system of rules, it would be very naive, I would say, or simplistic, right, to say, well, there are no such things as these are ordinary courts in the Netherlands. So I think that there is more than meets the eye in that sense. And second, I would say that it's a very much in flux also kind of debate, because there is there has been also a lot of evolution, and one that you have just mentioned is, for example, in the UK, where there has been a progressive kind of identification of courts that do administrative or judicial review, until the court called administrative court eventually was set up. So it's also a bit to some extent simplistic to stick to traditional subdivision or distinctions when everything is moving. And to some extent, I would almost say that maybe a diachronic comparison might even make sense, to look at how the court structure has evolved throughout the years. But I don't know, Rob, if I did justice to the Dutch legal system.
Rob, please. If
perhaps you make it even, you make it more rational than it is. We have, in fact, we have a rather strange system. Our first instance courts are integrated in the normal judiciary. So we have within the district courts, we have a sector criminal, sector civil, and a sector administrative. And the administrative sector has its own rules of the general administrative law. But then we have the appeal courts, appellate courts. They are not integrated in the system, and they are specific. So it is the Council of State, and then two others: Central Appeals Court and the Industrial Appeals Court. Why is this? Yeah, because they wanted to change it, but stopped halfway. So first we had the Council of State and the Central Appeal Court, etc. Then we had the first instance that was integrated. The idea was also to integrate the Council of State, etc. But then politics came by, and the Council of State didn't want to lose their judicial task, etc. So, and everybody thought, okay, it works. So that is typical pragmatic Dutch. So partly integrated in the normal judiciary. Partly it isn't.
I definitely think that this this specialization of courts and de facto specialization, so like Marielina says, more that meets the eye, is definitely a worthwhile further research avenue, because I think that if we include more legal systems, we could realize that even though there is no formal specialization of certain courts or as full institutions like environmental law courts, for instance, they may be de facto specialization of certain specific divisions in specific regional courts on certain issues that come, for instance, from for instance, from the rules on jurisdiction in certain areas. This is for instance the case in the country where I'm from, in Poland, where in Warsaw the regional administrative court in theory has general jurisdiction over administrative law cases, but it has some specialized internal divisions for dealing with special cases where some judges do specialize in certain issues. And then it's interesting because this may have a certain impact for issues such as the standard of review, right, and the intensity of review, or the easiness with which some judges may use procedural tools and do inquiry, etc., etc. So that's definitely would be a very fruitful, I think, idea for further research. But then I think I will give back the floor to Giulia, yeah, for on this. Or
if I can continue on this point, just a related question, because beyond the formal definition of the system, there is one relevant element, I think, that makes the difference still today, which is the combination between judicial and advisory functions within some administrative courts, which is typically typical of the French Council of State, as well as of the Italian Council of State. So Mariolina, what you think about this overlap of functions? This became in some cases a critical issue in the light also of the jurisprudence of the European Court of Human Rights. But beyond this very specific issue concerning the right to an independent tribunal and the right to a fair trial, what do you think about this combination of functions typical of some administrative courts?
Yeah, I must say, from the perspective of the book, this is not something that we have delved deep in, although perhaps it might have been fruitful to do so. It is also not, something that, it is true, as you say, that it is typical and quite entrenched into a number of legal systems. It's difficult to give an opinion really on this, as it seems. I don't know, if I think of the Council of State not having such function in Italy, it would seem very strange, let's say. So I wonder to which extent I am actually influenced by my own cultural biases, right? But at the same time, it seems that from the perspective of compliance with the ECHR, that the issue is solvable in that sense. So per se, I don't think that there are any legal impediments to such a set up if certain guarantees are in place. But it may be also time to reconsider why there is such a system, and maybe that's the product of, again, the historical evolution, but that doesn't mean that this is written in stone and it doesn't need to change. But there I also see that, because of course in the Netherlands there is also the similar construction as there is in Italy. So I saw also Rob that was nodding / not nodding, so perhaps he also wants to say something about this.
We have the same, we had the discussion on the Procula case of the Court of Human Rights, and the end of the discussion was some of them said, okay, we should get rid of the judicial function of the Council of State because they combine advisory and judicial functions, and it is possible that in their judicial function they have to deal with laws on which they have advised in the first place. So there has been discussion since then, but for now, the end of the discussion, but it can start again tomorrow. But for now, discussion has finished in a Chinese wall construction. So you have the building of the Council of State. If you go to the left, you come in advisory zone. If you go to the right, you are in the judiciary zone. And there are only a few, and I'm not sure, I should know this by heart, but I don't know it, a few of the state councillors who have a double function. Most of them only have a function in the judiciary division or in the advisory function. Only 2 or 3, 4 perhaps have a double function, and we try to get rid of all these double functions. So it is still one organ, but it has been split. But then again, there is always, again, every few years there is discussion. No, it's about, so it can change. No, but okay, for now, this is what it is.
Thank you. So now I think back to Giulio for the next round of questions.
Another very relevant argument, which is carefully analyzed with many cases in the book, is the issue of access to court, which is, of course, one fundamental issue which on one side defines, I think, the identity of a judicial review system, and on the other side is a fundamental tool for the protection of the public interest on one side and of individual rights on the other side. However, the issue of access to court is also characterized by many technical details which are managed by the legislator and even more by courts directly in the light of their jurisprudence. This issue of access to court has also raised a lot of criticism and tension in the clash between supranational law, in particular European Union law, but also international law, as in the case of the Treaty of Aarhus, for instance, the Aarhus Convention. On one side, a relevant extension of access to court, and on the other side, some countries such as Germany that are jealous of their strict access to court only to protect individual fundamental rights. So what emerges from your comparative analysis? I think on one side, for sure, there is an overall trend towards the extension of access to courts, which is coherent with the right-based approach, with the rights-based discourse. But is it always so? And are there some potential negative effects of this extension of access to court? Is there a cost in that, an individual cost or a collective cost? So I'm very curious to hear from you.
Thank you, Mariolina.
Thank you very much. So I think I would like to make two perhaps remarks on this. The first is, well, Giulio, you just mentioned, and I agree with you, that in general, what emerged from our analysis is a trend towards extension of access to court. But again, also there, and that is the benefit of the micro comparison, there is more that meets the eye. And again, here I can bring the example of the Netherlands, where there has been in the last years, in fact, a trend towards restriction of access to justice. In the Netherlands, there has been discussion, and I think it's a very worthwhile discussion also in comparative perspective, to which extent this kind of restrictive trend complies with EU law, complies with the Aarhus Convention, and so on. But there also, I think, while I agree with you that there is a trend towards extension because of the requirement imposed by supranational and international law, not all states would probably comply, let's say, as easily or in an as straightforward way as we might imagine. That would be my first comment. And the second, well, linked also to are there negative effects towards the extension of access to justice? there, again, to go back to maybe the rationale why in the Netherlands there is a trend towards restriction, one of the arguments was that restricting a too broad access to justice would, let's say, put a halt to economic investments because, for example, NGOs would bring claims that would have in turn suspensory effects, and therefore all the infrastructure project would be halted, that would have negative economic effects, and so on. I think that there is much more of a need for empirical research to prove this point, because it is easy to speak in the abstract that such claims would be perhaps, or well, I don't want to say frivolous, but would be mostly for the purposes of stopping the project, that there would not be per se, not necessary or not very often merits in these claims. But I think this is all a point to be proven empirically. And I know of a couple of years ago, for example, a German professor who did conduct research on claims brought by environmental NGOs, to the extent that back in the days was still possible under the Nature Conservation Act, if I remember correctly. And if I remember this research correctly, he proved that whenever NGOs managed to have access to court, their claims were more often than not successful in court. So one could also counteract by saying, well, perhaps there is more litigation, but maybe this is litigation that we ought to have if the courts are also there to protect the public interest. And to some extent, this is also necessary for the purposes of complying with international European standards. Of course, in countries, for example, like ours, where courts are already very overworked, one could also build the argument that there will simply not be enough manpower and capacity to deal with a surplus or an overflow of litigation. But I wonder whether that is a good argument for keeping the access to justice restrictive. But also there, I am happy to also hear the thoughts of the audience on that, as we have, I think, various models of access present here. Thank you.
We have one question relating particularly to this issue from the audience, from Isabel. So I would like to bring it to the floor. Isabel is asking, in terms of limits to access to justice, are these kind of limits only legal in nature, or perhaps there are also financial reasons or some other material access related limitations? And this is a very interesting methodological question. How can comparative work be done on these non-legal aspects? So please, Mariolina, if you could respond to this.
I think it's a question that goes very much to the core of, for example, public interest litigation. We know that there are certain requirements, again, from the Aarhus Convention about the costs of proceedings not being prohibitively expensive. But of course, that is it's very, if you wish, easy to check on paper, but it's very difficult to check in practice. Also, to which extent certain specific costs would, in practice, function as deterrent for NGOs from bringing proceedings. So I think that there is a very interesting methodological, well, maybe let's not speak about problems, but rather challenges, because this would go beyond the, well, if you wish, black letter law or even purely legal research, and would require a more on-the-ground empirical research, perhaps interviews with NGOs to understand the extent to which the costs of proceedings, and also the let's say the shifting of costs and the cost burdens between defendant and applicant do play a role, or what kind of a role they play in the decision as to whether they go into litigation, or perhaps they, with the limited funds they have, they rather do advocacy and campaign. So definitely, and that is not something which we went into the depth in our casebook, although we did cover the costs of the proceedings, but we really limited ourselves at that point to the legal provisions applicable.
But in this respect, I think your book very nicely also shows the avenues for further research. And I think Iselt is also would like also to add something on that, if I see correctly on my chat box. Iselt,
sorry, I'm fine. It was just a technical mistake. Sorry.
Okay, thank you so much. Okay, so now
Rob has a question, Michał, I think.
Yeah, sorry.
Yeah, only something to add a bit. It would be really interesting to have such comparative research, also including financial, etc. But also you should also include regulatory trends, because what was very important in the Netherlands for lowering the cases in the environmental area was that we have that the regulatory trends change from individual decisions to general rules. And what we have now is that most of the environmental activities don't need a permit anymore, but they should adhere to certain general rules, and if they don't, okay, there might be an enforcement action, but that happens sometimes, but not that much. So therefore, we skipped, I think, perhaps 2/3 of our. Now I don't know the numbers, but certainly the half of our cases was skipped, only by having a different regulatory trend, and so that had to be included as well. And by the way, that makes a difference. Although you can also file an action against general rules, but the general rule actions are before the civil courts, and the civil courts are more expensive, etc. And these cases never win. You don't win these cases on general rules, at least not that much. So therefore, it's very interesting even to include more.
Thank you very much.
If I can add just a point, Mariolina was rightly putting in connection the problem of access to court and the issue of overload of courts. And probably, as she was rightly saying, the solution is not limiting access to courts, but trying to streamline the judicial proceedings. And in this regard, there is another very interesting chapter of the book, which is devoted to these techniques, which also takes into account a very relevant experience made in the Netherlands and in Belgium about the so-called administrative loop and all the debate before the Constitutional Court of Belgium. So maybe one short comment by Mariolina on this issue could be very helpful.
Thank you. Well, the first comment I want to make is that this was a very difficult chapter to write because it does go very much into the technicalities also of the remedies before the administrative courts. So that had a difficulty in itself. And then there was an additional difficulty of finding which instruments to compare with which. So to create kind of macro categories in terms of, for example, mitigation of annulment, bypassing, reparation, and so on. So that is, I think you go also to the core of also what we wanted to also bring forward with that chapter. It is true that we did find these instruments in various shapes and forms in more or less all the legal systems we study in the book, but the importance and also the preeminence that they had in the different legal systems did vary. For example, I remember the UK author not being particularly concerned or finding it particularly spectacular to have bypassing or reparation powers. He concluded, well, it is at the discretion of the court. That's exactly what it ended for him. So it was not something that was particularly debated also from the perspective of right of the defense or separation of powers and so on. Whereas in other legal systems, that was much more well, felt, debated, discussed, and you have now mentioned the administrative loop in the Netherlands. I think that's probably the instrument that goes the furthest in terms of attempts to avoid annulment. At the same time, the research that I have understood has been done also in the Netherlands has shown that in practice, this instrument is not used very often. So that's also, yeah, I think what would be a nice, interesting avenue for further research would be to see how much, how often sort of the frequency of usage of the different instruments, because there's one thing in having them and one thing in the judge sort of wanting to use them, feeling comfortable about using them, and so on. And that might also reveal very interesting perspectives from a comparative point of view.
Thank you very much. We have in the chat one question, but I think the question is extremely interesting, but it relates to some organization issues. So I will take the liberty to leave this question for the end, if I may. And also on this one, if I can add one more question. I'm wondering, because we were talking about access to court and effectiveness or powers of and court remedies, etc. And we mentioned also this very important trend, especially related to environmental law and Aarhus Convention of expanding access to courts for NGOs. And as Mariolina mentioned, we have some trends to restrict actually access to courts, including, I know it is debated also in Ireland currently, to debated environment-related access to courts for certain issues, also because these questions, like currently in Poland, for instance, can be considered very political in connection with our current government's policy of cutting more and more trees, including in virgin forests, cases that came even to the Court of Justice. And I'm wondering, in light of these environmental especially challenges and climate challenges, now we hear more and more, for instance, about climate litigation, right? And use courts and administrative justice as measure of climate litigation. Shouldn't we also consider more the connection between the problem of access and the problem of remedies and procedures? I'm thinking especially if we broaden access to administrative courts for NGOs to bring environmental law cases, these cases are likely to be science intensive, right? Because this is a specificity of environmental law. And this, I think, brings us to the question of, are administrative law judges really capable of deal with science? Do they have sufficient procedural instruments to do that? Do they have, I don't know, advisory bodies? Can they appoint expert witnesses? In this respect, I find it very interesting that also in the book there is a separate chapter on the procedure and procedural tools. So I would like to ask Mariolina what she thinks about this connection, and is there some potential here for further research in this regard?
Thank you. I think that this makes a very nice connection also between various chapters of the book, which is, well, the chapter on access, the chapter on remedies, but then also the chapter of on the scope and intensity of review, where we try to assess kind of what is the intensity of review of administrative courts in comparative perspective, but then also linked to the, well, to the more procedural really side of the of judicial review process. And there, what we did find is quite some variation in the legal systems that we have analyzed, from a legal system, for example, such as the UK, where there is in abstract the possibility to appoint external experts, but this is hardly to never done, to situations in which, for example, well, that's similar in that sense to the EU legal system, where there is a procedural possibility to appoint experts, but that's probably, I would say, more than or less than rare even, that it takes place in practice, to situations with Germany and France, where there are possibilities to appoint external experts, which are appointed with a certain degree of frequency, although perhaps in Germany more than France, to this very peculiar system of the Netherlands, where there is this external foundation, which is, if you wish, at the service of administrative judges, where administrative judges can ask their opinion, or sorry, can ask their questions and receive an opinion from these independent foundations on various technical aspects of the dispute, which is probably, but there again, also I'm happy to hear from the floor, from the other legal systems, it seems to me that it's quite a unique construction in the European landscape. Now, of course, the ensuing question, and this is one where we are trying to also with a project that I am co-leading at the moment to find a bit more understanding about, is whether there is some degree a correlation between the intensity of judicial review, perhaps the constitutionally mandated, right, intensity of judicial review, the procedural tool at the disposal of the judge, and the willingness, the courage perhaps of the judge to engage in scientifically complex topics. So certainly there is, it seems, at least again from a black letter point of view, from a more law in the book perspective, there is quite some variation in the theme. Whether that now leads to, in practice, very different results, I would like to find out with that specific projects, but there is much more to be explored. And of course, if you look at it from the perspective of EU law, there is a very interesting question of uniform enforcement, uniform application of EU law, which may be threatened or jeopardized because of the different procedural setups that are in place in the legal systems.
Thank you very much, Mariolina. I think that at this moment, we would also open the floor to the questions from the audience. If there are more questions and you would like to intervene either by typing or I think you can also speak up if you like. So please just raise your hand or type your question in the chat. If there are no further questions yet, we're waiting for the questions. And in the meantime, I will bring to the floor this extremely interesting question from Eva, who's a researcher from Lithuania. Thank you very much for your question. I think it's extremely interesting. It relates to comparative administrative law and procedural in Central and Eastern Europe. So Eva would like to ask for you for a practical suggestion, how to find a publishing house that would be interested in publishing of a book relating to comparison between 8 different Central and Eastern European countries. And the book, as I mentioned, relates to comparative administrative law in these countries. If I understand correctly here from the description of the question, the book is already a work in progress. And I think it is a very interesting question because also before I was talking to Mariolina to very practical sort of problems related to a publication of such a book, which is mostly a volume of such a book, right? Because it's a huge endeavor to try to cover so many different jurisdictions, and also perhaps in the future, one of the future editions, but probably it would have to be 2 volume, could also integrate Western and Eastern Europe, because I also, and that's why I thank Eva for this question, I also think that Central and Eastern Europe would be an extremely interesting and insightful field of research on comparative administrative law, because either it provides interesting hybrids of different models, but it also provides its own original solutions. So Mariolina, the floor is yours. What you think about it, or what are your suggestions also?
Thank you. Yes, it's a very good question, but also a very difficult one. Of course, I can speak as a fellow researcher and not as affiliated to any publishing house, so that's a bit complicated for me. But from my hat as a researcher, I think that there is certainly a case for the book, because as Michal was saying, there is also very little available in English about these legal systems, and that is in itself already an added value and something new that is being brought to the table. So I think my main advice would be to stress the innovative nature of the project from the perspective of, in general, comparative public law scholarship thus far. And that, of course, links very much to the future of the casebook. This is a bit the comment that Michal was making before. If we would think, and I have to confess at this point that we are having a webinar and it's being recorded, that I am seriously thinking about a second edition of the casebook. Of course, the first question, apart from an update of it, the first question that I pose myself is, what should we, change, improve, add? Would it be even feasible to add more legal systems, to add another 2-3 legal systems? Would this book become marketable in the first place? I think in earlier discussions with some colleagues, someone had suggested, could one think of maybe an internet platform that is kind of a companion to the casebook to add more areas or more legal systems? I am wondering, and I think that's a point for discussion. And of course, the question is maybe linked to the first point that Giulio was mentioning in the beginning. Should this endeavor also include non-EU legal systems? Would we benefit also from a comparison with the US or Japan or India? Or would we lose a little bit sight of the main objective, which is this idea of the common law of Europe and so on? So these are, more questions than answers, really, but I'm also looking forward to discussing with Michal and then Giulio. Maybe Rob has an idea how could a second edition look like? What would be feasible?
Thank you very much. I again encourage our audience to ask more questions. In the meantime, I have one more question myself, if I may. So I hope I will not abuse my position by asking this question. One of the extremely interesting things also I find about your book is the inclusion of a chapter about non-judicial options and non-judicial redress mechanisms. So we have one chapter that focuses on the ombudsman and their role in the administrative, in the review, ombuds review of administrative action, and also redress mechanisms other than ombudsman, which is some alternative dispute settlement like internal reviews, conciliation, negotiated settlement, etc., and some kind of other amicable settlements mechanisms. And I think in this respect, it may be also perhaps in the future, or it may be useful to think about also administrative remedies. And of course, the focus here is on judicial review, but it is also my hunch, and it may also be the specificity of Central Eastern Europe, actually, or to be even more specific, of Poland or the country where I'm from. I think there is a certain relationship between the availability of judicial review and its effectiveness and prior administrative remedies. I remember some time ago, I had a fascinating discussion with a researcher, administrative law researcher in Portugal, who told me that in Portugal, administrative remedies were even considered a limitation of effective judicial protection by the Portuguese Constitutional Court. And it was somehow based on an empirical assumption that was taken for granted, that administrative law remedies, so before hierarchically superior administrative bodies, are inefficient, are ineffective. So they are limitation of proper effective judicial protection. Whereas in Poland, where I'm from, administrative remedies are highly effective. It's some time ago, a study was made showing that more than half of administrative law appeals are successful before. So it wouldn't even occur to me to think of them as a limitation to effective judicial protection. And also, I guess that specialized hierarchically superior bodies or quasi-judicial bodies can later facilitate judicial review. So is it, you think, also a potential avenue for research, Maria-Elena?
I would definitely think so. I have a sense that this goes back to some, again, historically, to the evolution of the system of administrative justice and the way this prior, what we call it prejudicial or non-objection procedure like remedies have been well, conceived and conceptualized. And there is a recent case also from the Court of Justice where the notion of the objection procedure has been considered in light of the notion of effective judicial protection. The way the question was posed and the way the question was also answered is this a limitation to effective judicial protection or access to court? And is this an acceptable, proportionate, right, limitation? So conceptually, sort of in the back of the mind, both of the referring judge and the court, it was phrased in these terms. Yeah, I think I think it's a product of history, but I think it would be very interesting to check also empirically to which extent these objection procedures do lead to a final, if you wish, settlement of the dispute, which also would deflate the court caseload and so on. And that is something that, to my knowledge, has not been done, at least in a comparative perspective.
Right. Thank you very much. And we have one more question in the chat. It's a very interesting question about the notion of culture. So could we, the way I understand the question is, can we say that something like administrative judicial culture, different administrative cultures, I think in different states, can they somehow play a role in this kind of comparative research? And how would we even define culture, how difficult it may be to define it, and then I assume also to research it. So do you think that this kind of cultural approach has Mariolina, would you like to answer?
From a very, let's say, anecdotal point of view, I feel like I should answer yes, because of course our casebook group had become a little like comparative ecosystem, right? With scholars from well, from the Netherlands, from Germany, from France, from the UK, I myself from Italy, and it is true that the way in which we approached certain topics were even unawarely the product of our, well, legal education and maybe legal culture, legal way of thinking. So I feel like saying yes from my own, in a way, personal experience of writing a big comparative law book, but how to touch it and how to research it is extremely difficult, of course. But it is clear that it is lingering there somewhere where comparative law scholars sit in a room. It is, no matter how much comparative experience they have, they all sit there with some own personal lens. And that ends up to different extents, of course, shaping the comparative discussion that one is able to have, and the way one analyzes and distills concepts. Now, that is also the advantage of the casebook methodology, and that is that this is the book is not structured by legal systems with maybe a final comparison in the end, but it's really structured by themes. And first, there is, let's say, a first part, a first phase, where all the national systems are brought to the fore. And then each author, although coming from one legal system, needs to take care of one chapter. Therefore, by necessity, having to deal with foreign legal systems. And that, of course, unveils questions and points that the national, say, reporter, let's call it this way, had never thought of. And I always bring the example of when we were writing the chapter on the forms of administrative action, where we were categorizing them in a way that is very continental, right? So single case decisions, general and concrete, general abstract, factual action. And we were asking the various national representatives to discuss the various forms in the various legal systems. But our UK author had literally no idea what we were talking about. There was literally no conceptualization in his mind that something like factual action would exist, which evidently doesn't mean that factual action does not exist in the UK, because police cars do drive around in the UK as well, except that in his mind, it had never occurred that this would be an actual category. So of course, there is no way one can shake off, let's say, the national lens. But to some extent, I think the casebook methodology allows us to go, well, beyond the judicial culture that we by necessity carry with us.
Thank you very much. I think it's an extremely important methodological point, and also this self-reflection of the authors. And I think it is extremely interesting that you asked your authors to focus on specific themes rather than just provide them with way to talk about their own jurisdiction. And I think this is one more reason to have a look at this extremely important book. We still have a few minutes for possible questions, if there are questions or comments or observations from the panelists or from the audience. So I definitely encourage you to ask your question or raise your hand also in the chat if you like. For now, I see no more questions, and we're very on time. So perhaps in this case, I will give the floor back to Mariolina, if you would like maybe to make some concluding
So I'm happy to well, to have the final remarks on this very nice webinar, and again, I hope that I have we have made you curious about the casebook, but also the willingness to further engage in comparative administrative law. We have discussed a number also of avenues for further research, so I'm very happy also to be in further touch with respect to them. And of course, going back to the review of European administrative law and its blog, we are also very happy, and me as also co-general editor, to receive submissions on comparative administrative law. And I think the work we have done with the casebook shows that there is a lot to be done in this area. There is also a lot to be discovered. And I really do hope that this will serve as a good starting point for further research on this. Thank you very much, Michał. Back to you.
Thank you very much. And from my perspective, I would like to say that I'm very happy knowing already the book that during the discussion, we touched upon every theme that I think was discussed in the book. So we talked about access, we talked about effectiveness, we talked about the procedure, and we have also, I think, managed to show that there are interconnections between these different themes, or also administrative remedies and out-of-court dispute or amicable resolution mechanisms. And from my own personal perspective, I can say that I'm also very happy that the topic of Central and Eastern Europe came up as a potential avenue for further research, or something that hopefully will be included in the next editions of the book. So thank you very much. And now for some last words, I will give the floor to Rob.
Yeah, my last words will be very short indeed. First, yeah, on behalf of the REALaw staff and person, yeah, many thanks to our panelists, Giulio, Michał, and Mariolina. Yeah, I think the discussion was really very nice, and we learned a lot. And I hope also that people who were listening thought, okay, these are things I'm interested in, because then you can also subscribe to REALaw, or at least ask your institution to become a subscriber, or whatever. And perhaps indeed send in an article or a blog, if you don't have time for an article, but you have a nice idea. And it might perhaps also be an idea already to have some contact on the Central and Eastern European issue. before, yeah, I think if there is a book growing, then there might be also a possibility of having an article on, which is not that big as a book, but which is very nice for our review of European administrative law. So indeed, so if you have an idea, let's hear it to us. Find us on a website, etc. It's not difficult to find us. And indeed, if you have a short idea or there is something happening, or perhaps in Poland, there was a decision today, for instance, then you can, at least I thought there was one about supremacy, etc. But that might be also interesting in for our blog, blogs, which will be very influential, of course, in some at some moments. Okay, thank you very much for all the nice words and the good discussion. And I think, shall I close the meeting? Okay, then hereby I close our conference. Thank you very much. Bye bye.